Good afternoon, everyone, and thanks for joining us for this week's Tea and Tech session, our weekly discussion panel looking at what's happening in tech law and the wider world. I'm David Chaplin, editor of Computers and Law, and this week, again, a slight change to the programme, I'm delighted to be joined by Lynn Penfold, General Counsel at the Rail Delivery Group, Gideon Shirazi, a barrister from 4 Pump Court, and Nick Watson, founder of both Ruby Datum, a data room company operating in the legal sector, and Law Tech London. Of course, while we are talking, the chat panel is open, so please do feel free to chip in with any comments and insights you might have about what we're talking about, and I will try and weave those into the conversation as and when appropriate. Before we get on to the main event, just a quick catch up on some of the other news and highlights we've covered on SCL.org this week. Firstly, a date for your diary. Di Davis is to deliver a talk on why Brexit made IT law bad for Britain. That's on the Tuesday, the 9th of March. That's our next event coming up, which I'm sure will be both provocative and informative. Just to highlight a couple of things that have been on SCL News, SCL.org News this week. They've been dominated by case law, and that's what we're going to be talking about later on today, a couple of cases that have come through, but also just a couple of other ones we've reported on copyright. One was an employee's failed bid to assert copyright in software that he developed largely in his own time at home. And another one was a copyright case that held that an XML schema is a literary work, not a database. The reasoning there was that when separated from the data, an XML schema loses its informative value, much like an individual words in a literary work cannot be separated from their literary value. So just keep an eye out for those, they're on the site. And also, maybe of note from this week's weekly roundup, which I hope you'll keep up to date with, is the DCMS response to a call for views on making representative actions under the Data Protection Act a bit easier. They've been rejected because they think that new legislation will be cause uncertainty for businesses in this area. So now let's turn to today's panelists, and our first topic for discussion today is the decision against Uber in the Supreme Court. We mentioned it briefly last week, but only just come out on the Friday. And Lynn is going to give us a quick run through of the issues and the background to the case. Over to you, Lynn.
Okay, so the reason that SCL is interested in this case is because it's really to do with a technology platform rather than employment law. It's an interesting case. It went through the Employment Tribunal, the Employment Appeal Tribunal, the Court of Appeal, and it ended up in the Supreme Court, where 6 judges, there were originally 7, but one of them got ill, looked at the case and they all dismissed the Uber appeal. So it started off with 2 drivers who were claiming that they wanted to be recognized as workers. And the reason that's important is because as a worker, you are entitled to certain statutory rights. So for example, minimum wage, paid annual leave, and also not to suffer detrimental treatment. So for example, by having taken Uber to court. So what I'm going to be looking at is, first of all, the legislation, and then the main legal points that the judges talked about, the main factual points on which they made their decision. And then we're going to have a discussion on whether Deliveroo and other similar platforms should be worried. So the question as to whether somebody is a worker or not is set out in the Employment Rights Act. And it includes anybody who's got a contract of employment, but it also includes self-employed people who work under a contract whereby an individual undertakes to do or to perform work personally or to provide services to another party who is not a client or a customer. The judges looked at this and they said that because it's an employment law issue, you should not be relying on the documents as between the worker and the employer. It's not a contractual approach, and you shouldn't be looking at it in terms of contractual interpretation. They decided that the correct approach comes from the Autocleanse case, where you're looking at the purpose of the relevant employment legislation. And the purpose was to give protection to vulnerable individuals who have little or no say over their pay and working conditions because they are in a subordinate and dependent position in relation to personal or organizations which exercise control over their work. And I think that's a key point in this judgment, the degree to which Uber had control over the work. The legislation, or the purpose of the legislation, is also to prevent employers who are frequently in a stronger bargaining position from contracting out of the protections. So that's what was in AutoCleanse, and that's what the judges decided was right. So you have to infer the relationship by conduct of the parties as opposed to looking at the contracts between them. So one example is that the Uber contract with the drivers expressly said that Uber was an agent for the drivers, and all they did was collect payments. But the judges found that there was just no basis in that assertion. They did see that Uber contracts with passengers, and then Uber engages a driver to do the work. So the judges focused on 5 factual points of conduct between Uber and the drivers. They established that Uber sets the fare. So Uber therefore decides exactly how much the driver is paid. The driver has no say in the contract terms that are imposed by Uber, and actually neither do the passengers. This is very much Uber's control. And once a driver is logged on, the driver can't refuse rides. So if it comes up on their app that they are to take a person from A to B, and if they refuse that too often, then Uber actually locks them out from the app and prevents them from working. Uber also exercises control on how the driver delivers the services. So for example, if a driver's rating isn't high enough, then the driver gets the boot. Uber determines what type of car the driver should have. It establishes the pickup location, and it even sets a recommended route, which if the driver doesn't follow, doesn't necessarily get them into trouble, but if the passenger complains, then the right is on Uber's side and not the driver's. And finally, Uber takes active steps to prevent the driver and the passenger from communicating. So, for example, the passenger can't choose which driver gets the assignment. Uber assigns that. Uber manages the fares and the complaints, and it sets out to minimize the interaction between the passenger and the driver. And it specifically prohibits the driver to exchange contact details with the passenger, so that if the passenger wanted to get that driver again, there's no way that they could reach them. So bearing all of that in mind, the court decided that the drivers are indeed workers. So they said that in a nutshell, Uber offers transportation services, which by the way, would incur VAT. So that's another thing that's coming. So transportation services performed by drivers in a very tightly controlled way. The drivers can't improve their economic position through skills. So they are subordinate and they are in a dependent relationship with Uber. And the only way they can earn more money is just by working more hours. And finally, they looked at whether the Uber app was in any way similar to the hotel booking platform, which is one of Uber's arguments. And they concluded that there are some similarities, but there are some very important differences. So in a hotel booking platform, the accommodation that is offered isn't defined by the booking platform, whereas with Uber, the ride that you get is. The customers have a choice of hotels in a booking platform, whereas with Uber, they don't have a choice of drivers. And quite importantly, the hotels will set the price that they are charging for a room. Unlike with Uber, where the app sets the price of the fare. There are no internal performance measurements in a hotel booking system. So sure, there are ratings for the hotel, but the app does not control who gets a booking depending on the performance rating that they get. And finally, the customer and the hotel can deal direct, whereas Uber was actively preventing drivers and passengers from establishing any kind of relationship. So with all that in mind, the judges concluded that the drivers are workers and they're entitled to minimum wages and statutory holiday pay under the working time regulations, which is really good news for the drivers. So the question now, as David put it, is should Deliveroo be worried?
I was going to say, I mean, what you've said there is interesting because it comes down to the degree of control of the app, isn't it? And I've tracked this case all the way from the employment tribunal because I also do some work in employment law. And I think this is off the top of my head, but I think in the employment tribunal, the judge actually said if it looks like a duck and it walks like a duck, it quacks, it is a duck. Yeah. And that's what when they're talking about the relationship that has been imposed by Uber, on their drivers. You can look at the contracts all you like, as you mentioned, but you have to actually the operation of the app was key. But I gather you've had a look at Deliveroo's terms and conditions, haven't you?
So I went into Deliveroo and how to become a Deliveroo deliverer. And first of all, I came across the website and it was all in French. And I thought, no, my legal skills and my French skills are not, they don't butt up. So I then found the English site.
Yeah.
They don't give you the terms and conditions, but you are invited to apply. And they say quite a few things on the website, from which I gathered that there are some similarities, but there are also some differences. So I must confess, I've never used Deliveroo. So this is all just what I got from the website, and seeing these poor bikers, around with their big boxes on their backs.
Yeah.
Under Deliveroo, the workers provide the transport, so the bicycle or the motorbike, but Deliveroo also provides visibility gear. I don't know if that matters or not. One of the big differences is that if you are a Deliveroo person, you can actually subcontract. So you can have a substitute, provided that they meet certain conditions. Under Uber, you can't do that. And I don't know whether you could therefore develop a business where you have the contract with Deliveroo, but actually you have 5 or 6 people picking stuff up and delivering it for you. Deliveroo, like Uber, does set the fees for each order, but the worker can accept tips in cash. With Uber, they can, but you're actually breaching the contract with Uber if you accept a tip in cash.
I love the fact that Uber, I love the fact that Uber also say you can, if you wish to, accept less. And they've sort of argued that's part of the freedom of as an independent contractor to take less money than you actually should get, which strikes me as odd.
Well, it's scraping the barrel, isn't it?
Yeah, it is. I think that's the right thing to.
And I think also that Deliveroo probably has less control in terms of ratings and substitutes and so on than Uber imposes on its drivers. So I imagine that people like Deliveroo and Just Eat are going to be looking at their terms and just making sure that all the sort of sweet spots that the judges found against Uber, they'll probably try and change them so that these people are not workers. I don't know how successful that will be.
Yeah, I mean, I might be wrong here, but I think that Uber set themselves. I don't think many other people would have acted in the same way, had the same control over their drivers as Uber. From what I've seen elsewhere.
Be surprised.
Yeah, be surprised. Who else then, Gideon?
Well, I mean, it's a really interesting judgment. I say that the very first case that I did about 10 years ago now was about whether someone was a worker. And it matters for the purpose of the working time regulation. It matters for the purpose of holiday pay. It also matters in the context of tax. There's something called IR35, and there's a not identical but similar test. The uncomfortable position for a lot of companies, not just companies like Uber and gig economy companies, but even all tech companies and banks and people like that who are employing people through service companies or even directly as individuals, is that there is a very significant chance that in real life, if you start applying these legal tests, turns out that they're workers, with the consequence that potentially there's very large holiday pay liabilities they could be due, other employment rights that they could get, and potentially even the risk of something against by Her Majesty's Revenue and Customs. The thing that really shocked me, actually, I should say, after doing that case 10 years ago now, was that there weren't loads of group actions being brought against companies for deductions for holiday pay, because the limitation periods for these things mean that you can claim things for very, very, for really quite substantial periods going back, and that there's a slightly different period in the employment tribunal, I should say, to there's a period in courts, and the amount of money that potentially turns on this could be enormous. If I were advising a company now, any significant company, I'd say, have a look very carefully at what's going on and work out what kind of liabilities you might be sitting on.
Yeah. Well, interestingly, I mean, it's only 25, this case only refers to actually 25 Uber drivers, doesn't it? And they're going back to the employment tribunal to find out how much they're actually going to have to pay now. But I think it might open some floodgates. But, and it's part of the wider move as well. I think, I mean, there's a couple of things I came across only today that we might mention on the site soon, that the ILO is looking at how digital platforms are going to be should be regulated so that workers can enforce their human rights, is really what they're saying. And so is the EU. The EU is looking at, is gathering evidence for how to regulate the employment of platform workers and whatever guise. And that could be Deliveroo and drivers and taxi drivers, but it also, as they're saying, is the platform workers on the Mechanical Turk, for example. Amazon's sort of pay by the piece service as well. So I think this is an area that's going to keep on moving, and it's in lockstep with the technology, isn't it? In a way, what the technology can do, it then has to be looked at as to what relations that creates. So, and I know, Nick, you were saying last night we had a quick chat. You were saying about maybe it has a knock-on effect for Uber because of the ethical side of things.
Yeah, I mean, Uber seemed to be in the news quite a lot for how they like to kind of dance around the grey areas. And my response to all these kinds of cases is if everyone just acted with a bit of honesty, integrity, and respect in the first place, we wouldn't actually have these cases in the first place. And I think that's how we should be doing business all the time. But obviously, the reality is quite different.
Yeah. Okay, well, I think we'll have to move on because we've got another biggie to talk about at the moment that came out last week, which is the High Court's judgment in the long-running Co-op IBM litigation, where the claimants are seeking 128 million in damages after failed IT project. Case is notable in at least one respect. There's many more than that, I believe, that it got that far at all. So it exposed a lot of what goes on in these cases. But Gideon, you're going to give us a brief background on the case, what the case is about, and what the outcome might mean for tech lawyers. At least a brief one, anyway.
Yeah, I mean, I think it's fair to say that for those of us on the line who do big technology implementation disputes, who've looked at the judgment, there are a lot of features of the judgment that are very familiar. Lots of clauses that people argue about a lot, lots of issues that people argue about a lot. The basic background is Co-op, in short, Co-op split into the insurance and the bank division. This is the Co-op insurance division, and the insurance division decided that it wanted to replace its legacy IT systems with a brand new IT system. It went to IBM. It said, I'd like to buy a system that works for me. IBM said, well, okay, we've got something that, or one of our subcontractors has something that fits the bill. We'll implement that, and then through a series of scrums, we'll produce and sprints, produce a nice new shiny system for you. When push came to shove, the implementation didn't go quite as nicely as everyone would have hoped. And CIS turned around and said, we're not very happy with all of this. And IBM said, well, okay, it's not ideal, but we think it's probably workable. CIS said, well, no, we're really not happy with this. IBM gave an invoice. CIS said, we're not paying this. And IBM said, okay, we'll terminate. CIS then turns around and says, you wrongfully terminated, and you were in breach of contract in various other ways. You weren't completely white as white in telling us what was going on. And the reason you terminated was for commercial reasons rather than because, rather than for other reasons. And taken in the round, you should pay us all the money that we wasted getting this system implemented. The judge basically said, there were lots and lots of allegations. I'm not going to go through all of them, but at its core, the judge said, yes, IBM did wrongfully terminate because you, co-op, were entitled to reject an invoice. And in consequence, co-op is entitled to various losses that are claimed, but a load of the losses that they claimed, their reliance losses over the course of the project, were excluded under the terms of an exclusion clause, which restricted the recovery of certain liabilities for things like loss of anticipated savings and loss of profits. And in an echo of the argument that was run in the Court of Appeal in Royal Exeter and Devon, the judge said, looking at these reliance losses are really a way of recovering expectation losses, which is the primary measure for contractual damages. Those expectation losses that are being claimed here are either loss of profits or loss of anticipated savings. Those are excluded, so you can't get around the cap just by claiming them on a reliance basis. That, I think, is the area of the case that a lot of people have picked up on and written articles about. There are a few other points that are probably worth noting. One of them is the court's approach to delays on the project, where what the court seems to have done is, what she seems to have done is picked up on the fact that there were specific deadlines but no EOT provisions in the contract, something that frankly isn't unusual in these in a lot of IT implementation contracts, and then considered how the law deals with that. What IBM argued was that there were a load of implied terms that would get round that, and the judge seems to have rejected the implied term that IBM said must be implied on the facts, but said that the prevention principle might apply, but on the facts of the case, she didn't need to decide whether it did. The prevention principle is something that comes up quite a bit in a lot of these cases. It's something that in the construction contracts, which the TCC is a lot more used to, parties are much better at excluding. And in shipbuilding contracts, which the commercial court is which is the other big area where it comes up, which tends to go to the commercial court. Again, the contracts, well, judges try to find ways often to read the contracts so that the prevention principle doesn't apply. It looks like this is yet another case where the court has said there is the prevention principle, it may or may not apply, but I don't need to decide that on the facts of this case. I think this is probably going to be an area where we see a lot more litigation in the future. Other areas that are particularly interesting are questions like whether IBM was entitled to terminate in the way in which it did, or whether it doing so meant that it was in willful default. And willful default is the argument that the co-op ran basically was that there's a willful default because they terminated for commercial reasons. And the judge said, well, maybe they did, maybe they didn't, but they thought that they were entitled to terminate in good faith, and they thought that their position was at least arguable, probably better. And even though I found it wrong, that doesn't mean that they were in willful default by terminating. Now, this is another area of the law that probably deserves a little bit more exploration, and on which there's probably going to be some further cases in coming years. The questions as to the extent to which wrongfully terminating can amount to a willful default. I say this is something that's going to come up in a lot of cases in coming years. There's obviously a lot of commentary on it in academic and professional papers, and it may well be, I don't know, but I thought there's a decent chance that in the coming year or so, we might see an appeal on some of these issues. So this may not be the end of it, even in the context of this case. Just picking up, Zoe O'Sullivan has asked, do you think that the judge was right to hold wasted expenditure was excluded? But it may be worth saying at this point, Zoe, I think, was involved in the Royal Exeter and Devon case. So Zoe, I'll be interested, Zoe, to hear your view on this, but perhaps offline sometime. I would have thought that whether I think there's two questions. The first is whether the judge was right that Royal Devon and Exeter is distinguishable. She said that it was, because it was a different type of benefit that was being sought. And secondly, whether Royal Devon and Exeter is right in and of itself. And thirdly, whether the clause in this contract is slightly different. I think it's probably a question for people with rather more knighthoods to decide, rather than me, at least at the moment.
Well, the response there was that yes, she came up with the argument in Royal Devon, so obviously she thinks it's right. So, big question: do you think this one's going to go? Co-op are going to appeal, don't you?
Yeah, I think at least Co-op, possibly IBM as well, might appeal. The values that are being talked about and the issues that are involved suggests to me that it's the kind of case where I'd be surprised if there wasn't an appeal. By at least one side.
At least one side. And what grounds? What grounds for IBM?
To be honest, I don't know, because I haven't really considered every aspect of the judgment in the level of detail that someone who would be looking at it to appeal is going for.
Go on.
I mean, as you know, Zoe is rightly pointing out, the wasted expenditure point is worth 100 million quid.
Yeah.
So, why on earth wouldn't you appeal?
Yeah.
If you could get permission.
Lynn, you found this case fascinating for some other reasons as well, don't you?
I found it fascinating for all sorts of reasons, because I think that it addressed a lot of issues that always go wrong in an IT project. And it was interesting to see, how the judge handled, for example, the fact that people could give evidence because they had contemporaneous notes. Now, a lot of the projects that I've been involved in, people talk and they argue and they have phone calls and there's emails, but there isn't anything terribly well organized to then show as evidence in court. It helps argue that you do need to have quite a lot of rigor when you're running a big program. And the more rigor you have, the better position you might be in. And also, don't forget the contract. Look at what the contract says in terms of, how you dispute an invoice. I know, this worked in the other way here, but don't ignore the contract when you're having trouble. See what it tells you to do so that you can at least put aside these arguments and do what the contract says.
And so these are things that you recognise, as you say, from your role as a general counsel, that you're handling these things, but having it exposed in a case is quite useful.
Yes, I mean, not so much as GC, but when I was working in, as the lawyer in disputes in IT companies, all the stuff that happened in this case comes up in many projects. And what was exciting for me is that this actually went to court, because more often than not, you sit there and you negotiate and you realize that, you have weaknesses and strengths on both sides. And it's probably the pragmatic way forward is to fix what went wrong and move forward and not sue each other. So this case is unusual because of having come to court with all these issues. I love it. Reading it again.
And how many paragraphs? 700 and something, I think. It's quite a long judgment. I mean, they're quite short paragraphs, it has to be said, but it's quite a long judgment. So it's a bit of a war and peace of a judgment, isn't it? I think
754.
754, yeah. So that keeps everybody entertained overnight. Coming into Nick.
Just to say, just before we move on, just to say there's an article on the SCL website on this case, written by Richard Osborne, who was on the other side of the Royal Devon case, and Lynn McCafferty QC. So if it's a case you're interested in, particularly on the reliance losses and exemption clauses, you might want to check it out on the SCL website.
Yeah, thanks, Gideon. Yeah, I was going to mention that. You've done it for much better than I would have done, so that's good. Just moving on to Nick, we have, that was a big case and it deserves some time. And as I think we may be coming back to this case in a more dedicated session, but we just wanted to deal with it today because it's fresh off the press. But Nick, from your point of view, as a technologist, you've got some thoughts around how, obviously we've been talking about contracts and all that sort of thing. You've got some thoughts you just wanted to air about maybe how we can improve and sort of diminish some of these disputes.
Yeah, sure. Firstly, I'm getting connection warning, so if I start going a bit robotic, I apologize. Yeah, my history is in technology as a developer, and I've come into the legal world a few years ago and seen a lot of similarities between legalese and code and this kind of thing. So I think the issue is it's around legalese being written for lawyers, and now we're living in a world of computers essentially, where computers have to interpret contracts in order to analyze them and display them to Joe Public, essentially people like me that can't necessarily fully understand without the role of in-house counsel there to hold my hand and tell me what things mean. So there has been a rise in kind of technology that make these kinds of things, because there's commas here that mean different things. Like a paragraph can be mean like something further down in the paragraph can relate to something at the beginning, and it can be quite confusing. So what I've started to look into is a whole smart contracts thing, where it's essentially, it becomes like a flow diagram. So if, then, and else, like with programming. So the beauty of that is that it can be presented to different parties and people involved in very different manners. So for example, in the case of an invoice dispute, you could actually have some computers software there that's already taken the input of the contract and displayed it to the person that wants to dispute the invoice and says, okay, so you want to dispute these invoices, these are your rights, this is what you can do, this is what you shouldn't do, and actually present complex legal procedures in order just to understand it. I guess kind of like, when you receive a mortgage, you're presented the key facts in a very easy to digest manner. You're given examples. I mean, it's very clear from the offset. And I think that's the way we need to go forward.
So you're describing this as legal design, aren't you?
Yeah, absolutely.
Yeah, I mean, which is a big buzzword. I mean, Lynn, have you got any thoughts on that as a way forward for your work?
I always think that that a contract is a living document in a project, and it's something that people should be able to understand. And there are very few parts of it that are really legalese, that you can't explain to people, look, we're doing it this way because something or other. So I really like drafting in the same way as I used to many years ago write a computer program, which was, you know, very, very list-like, and very clear what the options are, so that everybody can understand it. I think a contract that is so legalese that nobody understands it is no good for anybody apart from the lawyers. And what I want to have is a document that the people running the project can look at and understand and use it as a guide rather than as, you know, the thing you take out of the bottom drawer when things go bad.
I am reminded of a couple of years ago at the SCL, SCL annual conference. I think it might be one of Gideon's colleagues at Fort Pump Court did actually say all of these contracts are completely worthless because nobody looks at them afterwards. Yeah, he said I wouldn't even bother with the contract. I mean, that was, he was being provocative at the time.
That was Matthew, yeah.
Was it Matthew? It might have been Matthew. Yeah.
Sounds like Matthew.
It does sound like Matthew. Yes, I agree.
But we don't do ourselves any favors because, you know, for example, in the rail delivery group, and I know my colleague Ruth is listening in on this as well, you know, we spend 30-40 million pounds a year on IT stuff. And the people in the project see the contract as the last thing that you sort of need to think about when you want to get something over the line. Whereas what we're trying to do is to draft a document that they can own and understand and live with, so that they can see that, you know, the schedules are probably the most important bit, the bit that tells you, you know, what you're buying, how you want it delivered, how much it's going to cost, when you pay, what kind of meetings you have when things go wrong. You know, all of that is part of the living document that's the contract. And it's not the bump that you get in very small writing at some point in the process that you then forget about.
Do you recognize that, Nick? Is that the way you like to go?
Yeah, absolutely. It's that whenever I've had a contract drafted in the past, it's always been a case of, okay, so the lawyer will typically ask me for a few basic pieces of information and go to draft the contract in its extreme form and then send it back to me, and I you know, I'll just sign it, send it on to the other party, and it will come back covered in red ink, well, or Microsoft Word red lettering, and it will go backwards and forwards until we get to a place that we should just got to in the first place, where it's you know, they've taken the time to actually understand the commercial needs, the relationship I have with the supplier or client, and actually draft that in a fair form that's easy to digest and beneficial for both parties in the first place.
I actually was going to say on this. I think one of the really big problems in the IT space is that there aren't standard contracts. And I think a lot of these problems is the lack of standard contracts for standard things. And the reason I say that is if you look at other areas where they do projects, big engineering things, big construction things, shipbuilding, other big commercial projects, there are standard forms. And the way that people work with those standard forms is there are university and professional courses where contract administrators, engineers, architects, etc., go and get trained on exactly what steps they have to take when running a project. Nobody reads the contract in those industries either. But what they do is they have a standard. So everybody knows that it's exactly the same as every other project they've ever done. Whereas in the tech space, because everything is bespoke, every contract is different, human nature doesn't change. Nobody says, oh, great, I'm going to spend my time poring over contracts, except for lawyers.
Yeah.
Well, that's where we need to move away from, you know, that it shouldn't just be the lawyers who move. Sometimes I think that that drafting a contract and getting other people to input into the drafting is a little bit like that that parish council meeting that we saw that went viral. Yes, suddenly people change their language and they start using terminology and language that they don't use in a normal environment. You know, they suddenly get all legalistic, whereas a contract would be much more useful if it weren't like that, apart from obviously, you know, the legal principles of, you know, the limitation of liabilities, et cetera, because let's not forget, it is a commercial transaction, and a lot depends on the risk and the bargaining power. I'm also thinking of the standard contracts that that the government would put out in its public procurement processes. You know, they've got all those frameworks where, yes, they are standard contracts, and the NP-FIT contract, for example, was exactly the same as many other outsourcing contracts that I've seen for just, you know, normal IT. And yes, they're standard, and yes, they have the same clauses, but my God, the risk allocation was so unfair. I wish some of those had gone to court, because I bet you they would have been found to be, you know, too onerous, and then no chance of negotiating, and therefore they'd fall aside because of that. So yes, standard contracts, but let's make them fair.
Yes, an industry standard contract rather than one imposed by the government that shifts all liability to everybody except for them.
Yeah.
There is actually a pretty interesting project at the moment called One MDA. It's run by a lecturer from the Law Boutique. It's worth looking into, because I think it's just the start with something simple, but the way everything could end up going.
And one of the slight ironies of this is that our website address, the SCL website address, is scl.org, and scl.org.uk is the Society of Construction Lawyers, and they absolutely do have their standard contracts in place. So if you go to the wrong one, you will get a standard contract. Anyway, we've run over time a little bit, but I think that was all very worth it. It was a great discussion, so thanks a lot for that. And I think people have learned a lot from today's presentations and discussions. If you wish to show your appreciation for the efforts of the speakers, please do go to buymeacoffee.com/SCL. Any money raised there is funneled through to our student initiatives, so it helps support what we're doing there on the ground. You may also want to check out previous sessions. We've got recordings, podcasts, slides, etc. from what we've done this season and the previous season. That's at scl.org, there we go, /T&Tech. And finally, our next week, our panel will be Leah Grolman, Martin Sloan and Jason Coyne. So I hope you can join us again then. Thanks to you all, and have a good weekend.